Unit 29, group ownership, condos, cooperative, and ownership transfers. All right, so this unit's going to cover commercial properties that are often purchased by entities that are composed of many individual investors. The first part of this unit discusses real estate syndications. In the next section, the unit discusses condominiums and cooperatives. Finally, the unit deals with ways in which ownership is transferred. So this unit, we're going to cover the following topics. We're going to talk about real estate syndications, condos, condominiums, cooperatives, planned unit developments, inheritance, involuntary alienation, voluntary alienation. All right, so you're going to have to do some independent study. I'm going to go over the unit summary and the unit quiz. So for the unit summary, these are some key points you're going to need to take away to study for your exam. All partners in a general partnership have what? Full liability. Full liability. So all the partners have full liability. So if you have 4, 3, 5 partners, does one have more liability than the other? No, they all have full liability. In a limited partnership, right, only the general partners have full liability. So it's a big difference between limited partnership and general partnership. If you have a limited partnership, it's limiting the liability. So only the general partners have full liability. In a limited partnership, the limited partners are liable only for their investment. So if you go into a general partnership or if you go into a limited partnership, just understand that some partners may or may not have full liability for their investment. A corporation is a legal entity owned and controlled by shareholders, right? Shareholders own a corporation, right? A corporation, legal entity, never dies. That's why it cannot hold tenancy in common. A limited liability company is an entity owner and controlled by members. A trust is an entity under which title is transferred to a trustee to benefit beneficiaries. Right? Again, a trust is an entity under which title is going to be transferred to a trustee to benefit beneficiaries. A REIT, right, real estate and investment trust, REIT is what we call REIT, is a company with at least 100 investors. So if you have minimum 100 investors, you're going to be looking at a REIT. A REIT is a company with at least 100 investors that owns income producing real estate and provides favored tax treatment to the investors. So, you'll see big time investors. They'll try to pool a lot of people together, over 100 investors, and then we will refer to it as a REIT. Right? The sale of securities is regulated by blue sky laws. You'll hear the term blue sky laws. That's sale of securities, right? You're selling securities. And who are they enforced by? They're enforced by federal law, enforced by on a federal level by Securities and Exchange Commission, the SEC, right? So who regulates these trades of securities? It's regulated by the SEC, Securities and Exchange Commissions, and on a state level by the Arizona Corporation Commission. So you start your business, your LLC, is regulated by SEC and the Arizona Corporation Commission. In the condominium, the owner has fee simple ownership, right? We talked about this fee simple. Absolute would be the highest level of ownership. So fee simple ownership of their unit and shared ownership of the common areas. The owner of a condominium receives a tax bill for that individual unit, right? So if you own a condominium, you'll get a tax bill for that own individual unit. The rules governing a condominium are found in the bylaws. So if you buy a condo and you want to know more about the rules, where do you go? You go to the bylaws. Kind of like a HOA, the bylaws and the CC&Rs, covenant restrictions. those are the rules of living and owning those properties. The rules governing a condominium are found in the bylaws. In Arizona, a board of directors must meet at least annually, right? And the meetings are subject to the Arizona open meeting laws. So, big deal. To terminate a condominium, at least 80% of the condo owners must agree to terminate the condominium and must execute or ratify a termination agreement. So, again, to terminate a condo, at least 80% of the condo owners must agree to terminate the condo and must execute or ratify termination agreement. So, example, so say you have some investors and they don't want a condominium anymore. You got to meet at least once a year, and 80% of the owners must agree to terminate it. In a cooperative, a corporation holds title to the building, and the unit buyer purchases shares in the corporation. The stockholder receives a long-term proprietary lease for an apartment. The cooperative shareholder does not receive a tax bill. The taxes are levied on the entire property. A planned unit development, individuals own the building they live in and the land beneath the buildings, but common areas are jointly owned with the other owners of the development. Probate is a court proceeding. So, right, probate is a court proceeding that validates the will, totals the assets of the deceased, and distributes them to the heirs. If a person dies with the will, they have died testate, right? So what does it mean when you die with the will? Intestate or testate? Testate, right? If a person dies without a will, they have died intestate. So for example, me, my house, right? I own this house, I own a house, and I die, and I don't have a will. How did I die? Intestate, in no will, right? Intestate. I don't have a will. So when you die and you don't have a will, it's intestate. And if you died and you had a will, that is said to have died testate. So the difference between having a will and not having a will is testate, you had a will. Intestate, you didn't have a will. So meaning no intestate, no will, intestate. But if it's just straight up testate, you had a will. If a person dies testate, right, meaning they had a will, if a person dies testate and that person has no heirs, right, the property will pass to the state through the doctrine of escheat, right? So the person died, they had a will, and went to the heirs, but there's no heirs. Well, where does the property go then? The property will pass to the state. Property is going to go to the state of Arizona, and it's going to go through what we call the doctrine of escheat. Doctrine of escheat. There are three ways in which a property is transferred involuntarily, right? Involuntary meaning it's not, they didn't volunteer for this, are eminent domain, adverse possession, and foreclosure. All right, those are three ways you can transfer a property: eminent domain, adverse possession, and foreclosure. A voluntary is an uncoerced transfer of ownership. So you have involuntary. So there's three ways in which a property is transferred. Involuntary, right? Three ways. Involuntary is eminent domain, adverse possession, and foreclosure, right? Those are ways that you did not opt to do. You typically don't want to do those. And then if you want to do a transfer of ownership, voluntary, it's called an uncoerced transfer of ownership. All right, number one, which is an example of involuntary alienation? Involuntary, so you're not volunteering to do this. This is going to be a deed through foreclosure, right? So you miss your payments 3 months in a row, then you go into foreclosure, right? If you miss 3 payments on your house, right, you go into foreclosure. That's involuntary alienation. You didn't volunteer to go into foreclosure. That's a process that you will go through because you didn't pay your deed, you didn't pay your mortgage on time. So it's foreclosure and it's involuntary alienation. Mortgage, that is a voluntarily you apply to get a mortgage. You have to, deed of trust, deed of skin. You apply to get that. Um, deed in lieu of foreclosure. So it's not a deed in lieu of foreclosure. You didn't opt for that. It's a deed through foreclosure. So that could be a little tricky on the test. Number two, the rules governing a condo are found in the Bravo bylaws and corporate charter. So the bylaws, right? It's kind of like an HOA or a condo. They're sort of the same thing. Where are the rules located in a condo or HOA? They're located in the bylaws or the CC&Rs, the covenant and restrictions. So is it in the master deed? No, that's not where the rules are. Covenants, conditions, and restrictions? No, that was for an HOA, not a condo. Unit owner's deed? No. So the bylaws and the corporate charter, that's where the governing rules for a condo are located. If a partnership does not pay its debts, right? You got a partnership, they don't pay its debts, the creditors may collect from the personal assets of what? Of the general partners, right? The general partners, they have liability in a partnership, right? So a partnership, they don't pay their debts. Well, when the creditors come, so say you got a company, you open up a partnership, that means everybody's liable. All the general partners are liable, and they don't pay their debts. They get credit cards on the company's name. Well, who's going to be liable? All people in the company are liable, right? So, when you want to take on a position in a company, you want to make sure someone else in the company is not sketchy, because if they open up other credit cards or other stuff and you're on that business, then you could be liable to pay those debts. So the creditors may collect from the personal assets of general partners. And we're talking about personal assets, right? So limited partners, no. Stockholder of incorporated company, no. Real estate investment trust, no. Where do condominium owners' rights and limitations come from regarding the property usage? Declaration and bylaws. So where do condominium owners' rights and the limitations come from regarding the property usage? Comes from the declaration and bylaws, D. So we talked about this. Condos, HOAs, right? They have bylaws. That's where the rules are. HOAs have a step further, which is the CC&Rs. Condos, mainly the bylaws. So state law, no. Common law, no. Title insurance policy, no. 4 limited partners took out a loan for the purchase of an office building. The lender told them they would not be held personally liable on the note. This is an example of Charlie, non-recourse lending. Non-recourse lending. So 4 limited partners, right? Limited meaning there's limited liability there. 4 limited partners took out a loan for the purchase of an office building. The lender told them that they would not be held personally liable on the note. So this is an example of non-recourse lending. Non-recourse lending meaning they're not going to have personal liability, meaning their debts, they don't have to pay back the debts. So that's non-recourse lending. Is it subrogation? No. Subrogation financing? No. Disclaimer? No. Number 6, when a corporation would like to raise cash without creating new debt, they would most likely what? They would sell company stock. So again, when a corporation would when a corporation would like to raise cash without creating a new debt, they would most likely do what? They would sell company stock. So say, for example, Elon Musk, right? He wants to not get more debt on Tesla. So what is he going to do? He's going to sell company stock. And when he sells that stock, that's going to give more cash, and that's not going to give more debt on the company. He's just selling stock. So A says create a seller carryback loan? No. Borrow under a new conventional loan? No. Obtain a new SBA loan? No. Number 7, an example of voluntary alienation is what? Bravo, an assignment by an attorney in fact. So an example of voluntary, right? Your voluntary alienation. So voluntary alienation is an assignment by an attorney in fact. So you're volunteering for this assignment by attorney in fact. Attorney in fact is going to act in your behalf, and it's going to assign that. So is it A, acquisition under eminent domain? No. Loss of property through avulsion? No. Escheat of a property after a person dies intestate, right, without any will? Intestate, no will? No. So an example of voluntary alienation, voluntary assignment by an attorney in fact. When a member of a co-op sells their interest, they sell their what? They sell their leasehold interest, delta. So when a member of a co-op, there's two operations here, and they sell their interest, okay? They're selling their what? They're selling their leasehold interest because they have, they're a member. They both have a co-op interest. They're selling their leasehold interest. Are they selling their fee simple interest? No. Life estate? No. Reversionary estate, interstate? No. Their leasehold interest. Number 9, how can a corporation hold title? So how can a corporation hold title? It is in tenants in common. So this answer is C. A tenant in common, right? We talked about like two brothers, how they hold ownership or how they hold title. For two brothers, it'd be tenant in common. What about two sisters? Tenant in common. Two friends, tenant in common. What about marriage? That would be not tenant in common, be community property, right? So why is that? It's because there's undivided interest, right? So if a brother and another brother hold interest in a property, that's tenant in common, or a corporation hold title, tenant in common. When one dies, then they want to will it to someone else, or something's going to happen that's going to have undivided interest, right? Maybe 70%, 30%. You have tenant in common, and it's undivided interest. That's the whole thing here. So how can a corporation hold title? Community property? No, they're not married. Joint tenancy? No, there's not more than two. Tenant in common? Yes. In consortium? No. All the following relate to a limited liability company except what? So it is C, articles of a corporation. So all the following relate to limited liability except articles of incorporation. So members, are those limited liability? Yes. Limited liability in itself is limited liability. Articles of organization, right? Organization, you think of that, that's limited liability too. But what about articles of incorporation? That's LLC, right? That's related to limited liability companies, except articles of incorporation. That's not. So articles of incorporation, that's something else that you give up with the purpose. You write down the purpose of things. So members, yeah. Limited liability, yeah. Articles of organization, yeah. Articles of incorporation, no, that's a separate document you write for like the purpose of the company. That's what you call the articles of incorporation. Title would transfer involuntarily from all of the following except what? Executor. So title would transfer involuntarily in a sheriff. Yeah. So a sheriff, right? That's gonna transfer involuntarily. County treasurer, right? Sheriff, that's a person. County treasurer, that's a person. A trustee, that's a person. Executor, right, relates to a corporation, and they're not allowed to have joint tenancy in common. So that's the title would not transfer involuntarily, right? Ownership. So again, number 11. So sheriff is on the same level. County treasurer, trustee, those are people. Executor, that's related to a company. So ownership, where individuals own the building or unit they live in and the land beneath the building, but common areas are jointly owned with the other owners, is a what? Is a planned unit development. Planned unit development. So ownership where individuals own the building or unit they live in and the land beneath the buildings, but common areas are jointly owned with the other owners, is a planned unit development. So is it a condo? No. A cooperative? No. Apartment building? No. So again, ownership where individuals own the building or unit they live in and the land beneath the building. So like a single family home, that's going to be a planned unit development. But common areas are jointly owned with the other owners. It's called a planned unit development. Which of these must have at least 100 investors? So that is a REIT. We talked about this in the unit summary. So real estate investment trust, REIT, real estate investment trust, REIT, real estate investment trust, REIT. So real estate investment trust, which is called REIT, that's over 100 investors, and that's the minimum. That must have at least over 100 investors, and they all have some interest in the land. So is that a limited partnership? No. A limited liability company? No. A trust? No. Voluntary alienation is what? So voluntary, right? This is something you volunteer for. This is something you get. So transfer of property to heirs under a will? No. Taking of property by eminent domain? No. Foreclosure of a mortgage? No. An uncoerced transfer of ownership by deed or gift? 14. A voluntary alienation is what? Is a uncoerced transfer of ownership by deed or gift. So say someone transfers you ownership and they did it through a deed, right? Maybe like a quitclaim deed or through a gift. That's voluntary alienation, right? They volunteered for that. So a transfer property to heirs under a will. So A, right? That is involuntary. That's automatically going to happen. It's kind of a tricky question, tricky answer, because you think transfer of ownership to heirs under a will, that's going to happen automatically under a will, right? That's involuntary alienation. Taking of property by eminent domain, right? Eminent domain, the government's taking a private property for like a bill for a train, something like that. That's involuntary. Foreclosure, you miss 3 payments, right? The bank is going to foreclose on your property. That's involuntary alienation. We're talking about voluntary alienation, so it's an uncoerced transfer of ownership by deed or gift. You're just, being nice and you're transferring the deed or ownership through a gift or someone paid you, and that's voluntary alienation. If a person owns a condominium, they own a what? Alpha undivided interest in common areas and separate interest in the unit. right? So if a person owns a condominium, they own a undivided interest in common areas and a separate interest in the unit, right? Again, undivided interest in common areas, right? So in a common area is undivided, and a separate interest in the unit. So if a person owns a condo, that's how they hold title. B, undivided interest in the whole, separate interest in the unit and ownership of the land underlying the unit. No. So the key here is undivided interest in the common areas, right? That's when you own a condo, right? You have undivided interest in a common area. How about separate interest in the whole? No. Divided interest in common areas and undivided interest in the unit? No. So if you own a condominium, you own undivided interest in a common area and a separate interest in the unit, right? Undivided interest, common area, separate interest in the unit. It's two different things. When you owning a condominium, it's a little bit different than owning like a single family home. Under what form of ownership would each owner receive a separate property tax bill? So this one's C, condominium. So again, under what form of ownership, right? Condominium ownership, would each owner receive a separate property tax bill, right? So say you have a condo, you got two owners, right? Each of those owners is going to receive a separate property tax bill. That's pretty interesting, right? So if you got like four people who own a condo, you're going to have four separate tax bills, right? So each one of those owners own different interest in the land. So you could see four different tax bills on that condominium. So is it a timeshare? No. A cooperative? No. A general partnership? No. So under what form of ownership would each owner receive a separate property tax bill? That's going to be a condominium, right? Condominiums, they're very, very different. And that's where you would get separate tax bills, right? Because each owner owns a separate interest in the property. An owner interest in the condominium's common grounds is best described as what? Bravo, an undivided interest. See, so again, we talk about condominium, it's undivided interest, right? And they're both, if you got four owners, then they're all four, you guys are going to receive a separate property tax bill. Which of the following is not a form of involuntary alienation? So involuntary, not volunteering, involuntary, not volunteering. So this is, you're not volunteering for this. So a sheriff sale, no. Erosion, no. Trustee sale, no. So a dedication, yes. So which of the following is not a form of so it's tricky because they're saying not and involuntary, so not volunteer. So you think of, involuntary is a not volunteering. So a mortgage is a volunteer. So they want a not volunteering, not volunteering. So dedication. So they're looking for something you volunteer for, right? Not inventory. So a sheriff sale is you're getting evicted, right? That's involuntary. Erosion, someone is eroding, right? That's involuntary. Trustee sale, the trustee is selling it, and that's you're not volunteering it. Dedication, so that's voluntary alienation. Again, you're doing this as a gift or a deed, and you're doing this voluntarily. So the answer is D. 19. What is not an advantage of a corporation? What is not an advantage of a corporation? It is C, double taxation. Double taxation. So that's not an advantage of a corporation getting taxed twice. That's not an advantage, right? So limited liability, yes, right. So that's really good advantage. Officers appointed by a board of directors, yes. Double taxation, no. Limited living in perpetuity. So it's kind of a trick question. Living in perpetuity, a corporation can never die, right? So it lives forever, but that's not an advantage, really. That's just what it is. But what is that? So I guess it is sort of an advantage. That's an advantage. But double taxation, that's not an advantage, right? Being taxed twice, that's not going to be an advantage of a corporation. When a person dies with the will, so it's in so it's with testate, right? When a person dies with the will, so it's with testate, um, in testate, not in intestate. But which of the following statements will be false? So this one will be C. The estate would not be subject to probate because the party died with a will, right? That's false, right? Because it says with a will, and so the estate would not be subject to probate because the party died with a will. So the subject would be subject to probate, right? So an executor would oversee the probate process. Yes. An heir may contest the will. Yes. The estate would be subject to taxes before any property is transferred. Yes. So C, the estate would not be subject to probate. Incorrect. False. The estate would be subject to probate because the party died with a will, right? So you would be subject to probate with the will. And that's when the person dies with the will. That's false. A co-op charges taxes based on what? Pro rata share. A co-op, right? A co-op, they're going to charge. Co-op charges taxes based on pro rata share. Pro rata share is where a co-op, they're charging the taxes based on pro rata share. So is it based on square footage? No. Price of property sold? No. Appraisal? No. Pro rata share is when a co-op charges taxes based on that pro rata share. Blue sky laws. Okay. What do they regulate? Sales of securities and security brokers. So blue sky laws, they regulate the sales of securities and security brokers. Blue sky laws. Kind of weird. So again, you got the SEC, Security Exchange Commissions, and those sales of those securities, um, and that's called blue sky laws, and it's regulated by the sales of those securities and security brokers, and it's under the blue sky laws. So blue skies law do they regulate salesperson and person and broker commissions? No. Broker licenses? No. Out of state resorts? No. Blue sky laws, think of securities, and that's how they're regulated by blue sky laws. Which of the following relates to joint and several liability? Joint and several liability. So it is going to be Bravo, general partnership. General partnership relates to joint and several liability. So when you have a general partnership, right? You have general partnership. It relates to joint and several liability. Joint and several liability. That's general partnership. Is it limited partnership? No. Corporation? No. REIT? No. An agent would need a securities license in order to sell what? Real estate limited partnerships. Real estate limited partnerships. An agent. would need a securities license in order to sell real estate limited partnerships. Real estate limited partnerships. That's what, an agent needs secure licenses. So secure licenses, that's for under blue sky laws when you're selling securities, and an agent needs a securities license in order to sell real estate limited partnerships. Real estate. So do you need it to sell cooperatives or condos? No. As an agent, you have your real estate license, and that's where you sell. Apartment buildings, no. Um, Commercial property, no. So real estate limited partnerships, those are securities. Real estate limited partnerships are securities, and you need a securities license to. Public offering means what? So it means, bravo, stock can be offered to anyone who receives a prospectus. So that's a public offering. Stock can be offered to anyone who receives a prospectus. So anyone who receives a prospectus that's what's called a public offering. So it can be offered to anyone who receives a prospectus. So a stock can only be offered to residents of the state of Arizona. No, that's not a public offering. Stocks can be offered only to certain qualified wealthy investors. No, not a public offering. Stocks can be offered by licensed real estate agents. No. So stocks can be offered to anyone who receives a prospectus. That is what's meant to be a public offering. An owner who dies intestate, right? Intestate, no will, normally will have their property, bravo, transfer by descent to heirs. Transfer by descent to heirs. Transfer by descent to heirs. So it's transferred to descent to their heirs, right? So if you don't have a will, right, an owner who dies intestate, no will, normally will have their property transferred to their heirs, right? So if you don't have a will, you die, what happens? Your property goes typically to your heirs. Will it escheat to the state? No. So does it go to the state when you die if you don't have a will? No. Does it go to your heirs? Yes. Will it devised by will? No. Is it sold at auction? No. So if you die and you don't have a will, it goes to your heirs, right? And then I think if no one claims it after 7 years, then it goes to the state. A real estate investment that acts like a mutual fund but does not give you individual ownership is best described as a what? It's going to be a REIT, right? Real Estate Investment Trust, REIT, Real Estate Investment Trust, REIT. So that's when you have over 100 investors minimum, and it's a real estate investment that acts like a mutual fund, but does not give you individual ownership. So, there's 100 investors, say 200 investors, they own a condominium. Do they own the property? No. Do they own it like a mutual fund? Yes. So is it a real estate investment trust? No. Real estate option? No. Exchange? No. Which state agency regulates the sale of real estate securities? So which state agency regulates the sale of real estate securities? So this one's going to be Charlie, Arizona Corporation Commission. So we got the SEC and the Arizona Corporation Commission, Security Exchange Commission, and Arizona Corporation Commission. Those agencies regulate the sale of real estate securities. Right? So is it SEC? No. Arizona Department of Financial Institution? No. Is it Arizona Corporation Commission? Yes. Arizona Department of Real Estate? No. So which state agency regulates the sale of real estate securities? Real estate securities is going to be Arizona Corporation Commission. That's the same people you go to get your license with, your LLC. Arizona Corporation Commission, they regulate the sale of real estate securities. 29, in a co-op, what happens? B, each owner holds stock. So in a co-op, each owner holds stock. Each owner holds stock. So each owner has a deed? No. All owners are on one deed? No. The owners are tenants in common? No. So each owner holds stock. So in a co-op, each owner holds stock. A couple owns a condo in a community development. The development has an exercise facility that is funded by dues that all the homeowners pay. The couple does not use the exercise facility. The couple can what? It is delta. They do nothing and they have to pay their dues. So even if, so say you own, a condo in a community development and there's a facility there and you're exercising and you want to, you don't want to, you want to opt out, you want to pay less bills because you don't ever use that facility. Can you do that? No, you can't do anything about it. You still got to pay your dues, right? Because at any given time, you can still use it. Can you reduce your dues payment? No. Can you sell your rights to the exercise facility? No. Can you deduct the dues from your mortgage payment? No. The process of validating a will, totaling the assets of an estate, and transferring the property to the heirs of the deceased is what? Probate. So again, what is probate? Probate is the process of validating a will. So say you got a will and it's with testate. The process of validating that will is called probate, right? You're going to validate the will. You're going to read it. You're going to figure out who's it going to, what's the property, who does it convey to. So it's called probate. You're validating the will, and it totals the assets of an estate and transfers the property to the heirs of the deceased. So that process is called probate. So when you die, and if you have a will, testate, it goes to probate. And probate is just a process when you transfer your property to your heirs, right? So to the heirs, and the heirs get the property through probate, right? Probate is the process of transferring and it's validating a will. So the will has to be validated to make sure that that will was properly completed and from the deceased, and that is called probate, right? Validating that will is called probate. A condominium and cooperative would be the same in that what? Both pay annual assessments. So condominium and a co-op would be the same in that they both pay annual assessments, right? So condos and cooperatives, right? We talked about this, that each owner holds stock in a co-op, condos, so they both have to pay annual assessments. Do they both own fee simple absolute interest? No, that's the highest level of ownership. So with the condo, you can have multiple owners. Both own stock interest in the units? No. Both pay annual assessments? Yes. Both are leasehold estates? No. To terminate a condominium in Arizona, all apply except what? So except delta, if the property is sold following termination, the sale proceeds vest equally in the unit owners. No, right? Let's talk about a condominium, right? What do we know about condominiums? Unequal interest in the properties, right? So at least 80% of the condo owners must agree to terminate the condo. Yes. All the owners in favor of termination must execute or ratify a termination agreement. Yes. If the property is not to be sold following termination, title to all the real estate in the condominium vests in the unit owners as tenants in common. Yes. So D, right? It's the problem with this one is that it says the sale proceeds vest equally, right? There's nothing equal in the condominium, right? When you have multiple owners. What form of real estate financing would fall under federal securities laws? So this one's going to be Delta D, REIT. So real estate investment trust, right? Minimum 100 people, 100 investors, and that would fall under federal securities laws, right? So who regulates securities laws in Arizona? That's the Arizona Corporation Commission, with the securities SEC security SEC securities laws. So FHA, do they regulate securities laws? No. Agreement for sale? No. Conventional loan under 80%? No. REIT, right? That's the form of financing, real estate financing, right? It acts like a mutual fund, but you don't actually own any of the property. That's called a REIT. So if a person dies intestate, no will, right? Intestate, no will. The estate will what? Alpha, be handled by an administrator. So the person doesn't have a will, right? What happens to their property, their estate? Well, there's going to be an administrator that's going to give it to the heirs, right? They died with no will, so an administrator is going to handle that, and they'll be appointed, and they'll pass it down to the heirs, right? Be handled by an executor? No. Be given to the heir named in the will? No. Go to the state? No. So it's going to be handled by an administrator. All right, next up is going to be Unit 30, where we're going to talk about deeds.